Hello, my name is Aditya Gupta and I am a lawyer practicing at the Delhi High Court. Today I will be dealing with the module of trademark infringement and passing off. By the end of this module, I hope you will understand the different rights which are available in a trademark, both under the statute and under common law, the rules for determining infringement of trademark and the rules for finding out passing off, as well as the difference between trademark infringement and passing off. Let's begin. First, let's understand the nature of the rights that are available under a trademark. Rights are available to a trademark proprietor both under the statute and under common law. Statutory rights are available only with respect to registered trademarks. The Trademarks Act provides a detailed procedure for the registration of marks, and if a trademark is granted by the trademark registry, then the proprietor of such a registered trademark is entitled to certain rights under the statute. In contrast, even if a trademark is not registered, there are rights which are available under common law. Therefore, a person may not have gotten a registration under the Trademarks Act, but he or she will still be entitled to certain rights under common law. Typically, even registered proprietors of trademarks claim common law rights. That is, they say that while they are entitled to the rights under the Trademarks Act, they are also entitled to common law rights with respect to the goodwill and reputation that they have developed over the years. Section 27 of the Trademarks Act is relevant here. Section 27 says that no suit for infringement of a trademark can be filed with respect to an unregistered trademark, but at the same time it contains a savings clause. It says that the first part of section 27 will not affect the ability of a person to claim passing off of an unregistered trademark. I hope you now understand the correlation between the statutory and common law rights available to a trademark proprietor. If a person is able to obtain a registration for a trademark, he is entitled to two rights under the Act. The one is the right to use the trademark in the course of trade, and the second is the right to obtain relief, that is, the right to stop others from using the trademark in the course of trade. Therefore, for instance, McDonald's, the burger chain, is able to obtain a registration for the trademark McSwirl. The trademark registration gives the McDonald's two rights, that is, the right to use the trademark McSwirl, as well the right to obtain relief against another person who uses the trademark McSwirl for ice creams. Now let's understand the test for infringement of a trademark. There are four situations possible here. A defendant or an infringer may be using an identical mark for identical goods or services. For example, someone uses Tata for steel. As you know, the Tata Group is the owner of the Tata trademark and it makes steel, and since the infringer is using an identical trademark for identical goods, this amounts to infringement of trademark. The next situation is where someone uses a similar mark for identical goods or services. Again, taking the Tata example, let's say someone uses the trademark Tattva for steel. Here, the trademark is similar to the Tata trademark and the goods are identical. Third is where the use is of an identical trademark for similar goods or services. I'll take the Tata example again. Compare Tata for steel versus Tata for cement. Here, the goods are different, but they're still similar in nature and the marks are identical. Lastly, where the use of a similar mark is made for similar goods or services. Again, Tata for steel versus Tattva for cement. All of these four situations are captured under the Trademarks Act and are considered infringement of a trademark. Now let's move on to this concept, from whose eyes should likelihood of confusion be judged. Way back in the year 1962, the Supreme Court of India identified such a person from whose eyes the likelihood of confusion needs to be judged. The likelihood of confusion needs to be judged from the eyes of an unwary consumer with average intelligence and imperfect recollection. Now, when I say confusion, you must understand that the bedrock of trademark law is confusion. Trademark law exists to prevent consumer confusion insofar as you do not want consumers to be confused as regards the source of the goods. Therefore, the courts have laid down this test keeping in mind the common man, and they believe that the common man will have average intelligence and imperfect recollection. The common man will not remember the details of each and every mark and will not thus be able to distinguish the marks by keeping them side by side. That's why the test seems to be a low one. The threshold seems to be a low one. The question is, does this test also apply to more expensive goods? For instance, if a person is going to buy a car, is it likely that he will be more discerning regarding the goods that he is buying? Will he not find out more about the car and will ensure that the brand that he is buying is the one that he intends to buy? Courts do consider this factor when determining the likelihood of confusion, and for more expensive goods, there are certain courts which have held that a more discerning standard must be adopted. Now let's move on to the question of how do consumers interact with trademarks. This is important for you to understand the tests which have evolved over the year for determining the similarity between trademarks. Let's go over these one by one. First is, the brand itself is not a memory target. What does this mean? This means that consumers don't necessarily remember the brand immediately, and it is only a cue that facilitates the recall of previously learned brand associations. This means that a person may not remember the brand exactly. It may have certain associations with certain parts of the brand, and this may be a word, a numeral, a trade dress, anything of that nature which is distinctive. Therefore, distinctive brands and packaging are highly conducive to mental associations. The consumers associate a particular distinctive part of a product with a particular brand or a particular source of goods. What happens if someone else starts using a similar mark? It causes a slow decline in the accuracy of consumers' memory-based judgment. This means that consumers start doubting that whether the association that they had with a particular brand is correct or not, whether they can any longer rely on a particular word, numeral or type of packaging to be sure that the product comes from a particular source. Therefore, Trademarks Act seeks to put a check on such practices to ensure that there is no decline in the accuracy of consumer-based memory judgment. This means that there should be no consumer confusion. Now that you know the rules of how consumers interact with trademarks, let's see the rules for determining the similarity of trademarks. It is now well settled that the side-by-side comparison of trademarks is inappropriate. What the courts have realized is that consumers usually do not have the proprietors and the infringers' trademarks side by side for comparison. Usually, the consumer is relying on some old memory association that it has with a brand, and therefore, it is in that light that courts must also judge the similarity of trademarks.